Hello, friends. We're dealing with domestic violence injunction cases today in part 2 of our 3-part series called the Trifecta. When you have a criminal domestic violence case, a civil domestic violence case, as well as a family court case. Welcome back to the Divorce Broadcast. My name is Manny Segarra, coming to you from Miami, Florida. We have two amazing guests, Mr. Scott F. Kotler, criminal defense attorney at law, who is back on the show, and Miss Irech Morales in Orlando, family law attorney extraordinaire. Friend of the show, we just love having her on here, so we keep making her come back. Welcome back to the two of you. We are moving on now to domestic violence injunction cases. And Scott, can you kind of tell us, how do we get here usually for these DV injunction cases? What is the genesis of these cases?
So essentially, it starts off typically with the criminal arrest and the criminal stay away order, but the police and or the state attorney's office will tell the victims to go to civil court, to the family courthouse, and to take out what's called a temporary restraining order, they're not simple, they're complicated, but it's a civil restraining order. It'll start out temporary and then it turns into a permanent if a certain burden is met. And those, when entered permanently, last forever, versus the criminal, which will end once the criminal sanctions are over.
All right. So that domestic violence statute in Florida is governed by Florida Statute 741. And I know that there are different types of injunctions. Some of them include between family members. Some of them include repeat violence. Some of them include stalking cases. Is that kind of the area of law that we're talking about, Scott?
Yes, it is. They actually map out a number of different subparts of that statute. And as you said, there are some for domestic violence, whether it's husband, wife, boyfriend, girlfriend, could be sisters, brothers. You have non-domestic, where the people may just be strangers and they get into, a situation where there's multiple confrontations and they meet the statutory requirements to take out a non-domestic stay away order, as well as stalking and things of that nature. So there's a number of different subsections, and you have to familiarize yourself with the different requirements of each statute.
Good stuff. So I'm going to ask you both, in these types of cases, there are petitioner and respondents. What usually happens with the petitioner, Irech?
So usually the petitioner will, march on to the civil courthouse. They will file a petition for protection against domestic violence. Ideally, that petition is very lengthy. It'll include all their allegations against the respondent. And it's important to know that in these kind of cases, they're not referred as husband and wife. They are petitioner and respondent. The court will then have to review the four corners of that petition to determine whether an ex parte temporary injunction will be entered. Within that temporary injunction that is entered, it does include a hearing date, which is unilaterally scheduled by the court to be able to determine whether a permanent injunction will be entered.
So let me just interject. Do you mean someone can go into a courthouse or a clerk's office, ask for a document that would essentially allow them to not have contact with somebody and do it without anybody knowing about it?
Correct. So I did mention the word ex parte. So that means that ideally the court will enter an order without a hearing, without informing the respondent. And what they do is that they look at whether the allegations in there is sufficient to prompt that temporary injunction. Once that temporary injunction is entered, then what they got to do is find the respondent and then serve them with those documents.
Interesting stuff. I know that Scott's due process DNA in his body just churned a little bit when they execute ex parte orders. All right. So what are some of the things that appear in these injunctions? You mentioned that there's an automatic hearing date. Scott, are you aware how far away the respondent has to stay away from the petitioner, the person asking for the injunction?
Yeah, my understanding is it's the same as in the criminal order. It's 500 feet from them, their place of work, their residence, if I'm not mistaken. And again, the client or the respondent many times will have no idea this has been entered into.
Interesting stuff. Irech, in your experience, what happens with the children in these injunctions?
Unfortunately, a lot of times once the temporary injunction is entered, the court will grant 100% time sharing to the petitioner, and they will input terms in the temporary injunction stating that there's no contact with the petitioner as well as the minor children. And this will also include anywhere the children are, including their school or home. So even if the respondent is paying for that home, it's titled in his or her name, unfortunately, they're not allowed to go within 500 feet of them and the children.
So a court order that you don't even know about restricts you from having access to your kids and kicks you out of the home that you are actually paying for. That's some pretty serious stuff. Scott, so once an injunction is entered by a court, do you know what the police department starts to do after that order is entered?
Well, basically, they'll look to serve you, and the petitioner needs to give an address where they believe you're staying. They'll come out looking for you to personally serve you with that document and run through it with you. They'll also instruct you that if you own any firearms or ammunition, you have to turn it into law enforcement, immediately. These are rights that everybody has, and they are taken away based on this ex parte document. And I will tell you that I don't think I've had one, and I've probably handled hundreds and hundreds of these. And not one time have I ever had the respondent come in and look at the allegations in the affidavit and say, yeah, that's all correct. No, this is not true. This is not true. She or he is lying about this. They've embellished. Yet, based on that one-sided story, some serious court activity is taking place.
That's right. It seems like it's a pretty intense thing. So what about enforcement in different states or statewide, Irech?
So ideally, the stay away order or the temporary injunction case in the civil case will be enforceable everywhere in the state of Florida. However, they do need to be aware, when I say they, is all the respondents, is that it could be given full faith and credit in other states.
And what about in terms of the petitioner? Are they allowed to contact the respondent once the injunction's in place?
Absolutely not. And this is something that a lot of petitioners are either unaware or they choose to not heed our counsel, but the injunction is mutual. Just because the respondent is not allowed to contact you, you should also make, as the petitioner, a best effort and completely avoid contacting the respondent, because a lot of times you have to consider some of the burdens of proof in this case, which require a lot of times that you are claiming that you are in danger, you're scared for your safety. And if there is a presumption that you are contacting the respondent, it kind of shies away from those allegations that are in the petition.
I think that's kind of a valid point when it comes to defending these cases, Scott, when you see that the petitioner is having contact with the respondent.
It's a very sticky situation. I've seen cases where the petitioner will reach out for the respondent, but they can't get in trouble. Even though they shouldn't do it, they can't get in trouble. I had a client once who was in jail on some very serious domestic violence charges, and I was successful in convincing the court to let him out on house arrest. And his phone rang, and then it stopped, and he looked and he saw on his caller ID a call from the petitioner. And so he called the petitioner back, and she answered, and she stated, I accidentally dialed your number. I'm sorry. And he took that opportunity to say, well, how are you doing? I'm really sorry.
Oh, no.
Well, I'm supposed to be talking to you. And they hung up, and she went to the prosecutor, and they went back to court. And based on that, he landed back in jail because he should not have returned that phone call, whether it was intentional or not. The stay away order is against the respondent. They can get in trouble. The petitioner generally can't.
So you had previously mentioned that you immediately have to turn in your firearms, but what about when you want to go get your stuff, Scott? What happens there?
Usually the court will instruct that you have one chance at going back to the house within 24 to 48 hours. It must, I repeat, it must be police escorted, and they're only going to give you about 15 or 20 minutes at best. So you're not going to be able to clear out all your belongings. Essentially, it's an opportunity to get money, passport, jewelry, things of that nature. And that's basically it until likes of Manny and when you guys get in there and get additional ability to get in.
What about exclusive use of the house you mentioned, Irech? And one of the soft spots that I have, exclusive use of what else?
Yeah, so in the temporary injunction, it will also include terms as to which party has exclusive use and possession of the home, whether it be a home you're renting or a home that is owned. Essentially, the petitioner will oftentimes get exclusive use of that home. So a lot of times the respondent has to find a place where to go. It could be somebody's couch. It could be with their mom, their dad, a friend. It could be anywhere else but that home. And unfortunately, there also is terms for exclusive use of pets. Maybe there is some allegations involving pets as well. Or sometimes if the pet is combined to a home, obviously, you got to stay away.
So no more Fido for you. And also the children, right?
Correct.
And what about child support?
Yes. So the injunction will also include any kind of provisions for temporary support. Sometimes it will, sometimes it won't. It will be dependent on the case and if there's any financial issues that the court is made aware of. However, for temporary support, that is something that we can also tackle in family law case, which we'll get to in a little bit.
So if I understand you both correctly, if a person gets arrested for domestic violence, the police will tell the victim to go get an injunction, at which point that person will file a petition, which will give them no contact with the other person for 500 feet, exclusive use of the house, 100% time sharing, 100% parental responsibility, a child support order, the pets, and you can't have a gun or firearm, and you can't have anyone contact that person. Does that about sum up what happens to you if you get an injunction?
Yep, that sounds about right.
And one opportunity to get into the house where you have about 15 or 20 minutes to get whatever you can grab. And let me toss a question over to Irech, if I may. I recently had this question where the client said, well, I pay the rent every month. I can't be there. I'm living in a hotel and I have the rent is due tomorrow. Should I pay it or not? Now, my answer to him was, number one, I'm going to ask you to consult your family law attorney. But my belief and my response to your question would be that I think you should, because I'm going to suspect that somewhere down the road, you're going to be in front of a family court judge dealing with divorce and custody issues. And the last thing you want that judge hearing is that you decided not to pay the rent because you couldn't stay there and your wife and children were forced to go to the street or a shelter. I don't think that will look good for you. And would you really want your children potentially being thrown out on the street? I said, but consult with your family law attorney.
You are very correct, Scott. Everything you just said is very, very correct. Unfortunately, that respondent will still need to pay everything that they have continued to pay throughout the marriage. And there's some, terms that we can go into in the family law case, but ideally you're correct in that response.
Good stuff. All right. So the final part that I want to touch upon is something that I want to get both of your thoughts about, and that is the difference between a final hearing in criminal court, which is a criminal case, versus a final hearing in a domestic violence civil injunction. So Scott, burden of proof must be a little bit different in both.
Yes. In a criminal case, the government has the burden to prove the allegations beyond a reasonable doubt. It's a very high standard versus in the civil injunction hearing, the petitioner must convince the court by a preponderance of the evidence, which is tipping those scales a little bit more in favor, 51, 52%. It's a much lower burden. One, the criminal case, you're dealing with potentially somebody's liberty versus the civil, you're dealing with non-liberty issues, money, child visitation, things like that. So two different standards. The restraining order is much easier to prove. And you also run into a very unique situation where I'll have these restraining order hearings come up. And ideally, I'm going to want the respondent to testify and rebut the allegations that he was jumping up and down about when he read them in the petition. But he's got an open criminal case, where in the criminal case, he's got the right to remain silent. And I may not necessarily want any statements coming out of his mouth that could be used in the criminal case. But if he doesn't testify in the restraining order hearing, then he doesn't get his side out. So it's a very fine line, and I have to balance and weigh what his testimony is going to be. Will it help him in the petition? Will it hurt him in the criminal? And then make a decision.
Quite a balancing test, my friend. In criminal court, you don't. You have an absolute right to remain silent. But what's interesting in these DV cases, Irech, is what happens if you remain silent? What does a judge do?
Yeah, unfortunately, they can use your silence against you without you providing any testimony with, kind of what Scott mentioned, their side of the story. All they have in front of them is either some evidence or the petitioner's side. So it makes it very difficult. And by way of the respondent saying silent, you kind of just toss the coin, and there's only one judge at the end of the day in the civil case that will make a determination for you.
Yes, it's only one person that you have to convince either way. And Scott, you got a jury of your peers, I guess.
Correct.
Yes, you do. 6 members of the community, unless of course it's a capital murder case.
All right, good stuff. So before we talk about how this leads into a divorce case, Scott, if people want to reach out to you, go ahead and give them the best contact information.
So what I do is I put my cell number out there because unfortunately you never know when one of these situations will arise. I'm available 24/7. The number is 305-804-2436. That's my cell number. It'll either come directly to me, my legal assistant, Jennifer, or to a live service who will immediately get me the message.
Good stuff. All right. Well, thank you both for sharing on part 2 of our Trifecta broadcast. If you know anyone that may need help with this, have them look us up at www.segarralawfirm.com. We have offices in Miami and Orlando, Florida. Se habla español. Please do us a favor and like this video, subscribe to the divorce broadcast, and share this video. And we will see you all soon.